Hello, everyone. I'm trying to get on Instagram. I don't think I'm getting on Instagram. Okay, I'm live on Instagram. Good morning, everyone. Oh my goodness, what is going on here? Just give me a second to get back on Instagram. Start again. All right, let's see how I can get back on Instagram. Okay, guys, I'm not sure what's happening on Instagram, but I'm here today to discuss. Okay, this is the reason. All right. I'm going to have to start again, guys. Instagram is not working today, so I will keep on Facebook and YouTube. Okay, Instagram is back. All right, this is really embarrassing. You know what? I think I'm just going to go off of Instagram because it's not working today. So Facebook and YouTube, you have me all to yourself. Good morning, everyone. My name is Ifeoma Odunlami, immigration attorney from the Odunlami Law Firm in New Jersey. Good morning, everyone. Please join me. Please let me know where you're joining me from. Say hello in the comment section so I know you're here. And I have a good topic for you guys. I'm going to answer some of your FAQs on this topic. So today I'm talking about when you have a green card and it's a temporary green card, right? And you want to get your permanent green card. So we're going to go through that scenario and discuss that and a couple of questions. How do you get a green card, especially when your spouse is refusing to assist you? So I'm going to talk about this for those people who already have a temporary green card, which is a 2-year green card. And you know that the way to get it is if you're married to a U.S. citizen, right? And or a green card holder, and at the time you get your green card, your marriage is less than 2 years. Then you have a temporary green card, which is just 2 years. For you to get the 10-year green card, which is known as a permanent green card, you have to remove the conditions on the temporary green card. And you have to remove it within 90 days of the second anniversary of your green card, of the second anniversary. So if you're not sure what you have, if you're not sure if you have a temporary green card or if you have a permanent green card, look at your green card. If it tells you that it's for 2 years, then you have a temporary green card. If it says it's for 10 years, that's a permanent green card. All right. So now a lot of people make this mistake. So listen up. This mistake they make is when the temporary green card expires, they file the I-90 to renew it. That's not what you're supposed to do. If your temporary green card expires, you're supposed to renew the condition, remove the conditions. So you only renew a permanent green card. That's a 10-year green card. And the reason I tell you guys this is because sometimes when you make this mistake, that mistake can be costly, because if you don't remove the conditions on time and your green card expires, USCIS can issue what we call a notice to appear, which puts you in immigration court. That's deportation proceedings. So you want to avoid that. So today we're going to talk about what to do if your 2-year green card is expiring and you want to get your permanent green card. Now, typically, to do this, you're supposed to file jointly with your spouse. And the form to fill out is called the I751, the form I751. Now, you're supposed to fill it out with your spouse. Your spouse has a section where he or she's going to sign, and you have the section where you're going to sign. And then you're supposed to submit it with evidence that your marriage was a bona fide marriage when you entered into it and still is a bona fide marriage. And what do I mean by bona fide? I mean that at the time you entered the relationship, the marriage, your intention was to have a life together, that you got married for real, and you did not get married just for immigration purposes. That's what a bona fide marriage is. And typically they're looking at what your intention was at the beginning of the marriage. So now, how do you provide this proof of a bona fide marriage to USCIS? Now, if you remember, at the time you did the first petition, right? The I-130 with the adjustment of status and all that. If you're here in the United States, when you did that, you provided certain documents to show that you were legitimately married for love or companionship and all that. So what are the things you submitted? Well, some of the things you submitted were probably a lease agreement or a mortgage showing that both of you signed the lease or signed the mortgage, or that you are somebody who is allowed to live in the apartment if you didn't sign the lease, right? Now, everyone's not going to have the same evidence, but the thing is that it's the totality of the evidence that you submit that determines whether your evidence is convincing, right? So I have some people who say, well, my spouse was not on the lease for whatever reason, or maybe you guys live with a family member, and you're paying rent, maybe renting a room. Then in that case, get a letter, an affidavit from the landlord saying that you live there, but both of you live together. Or you can get an affidavit from your neighbors who know you, who can say that both of you, they know you guys to be a couple. So these are the things you submitted. You had to submit, if you had that proof of financial commingling. Immigration loves proof of financial commingling because I think they believe that if you're married for real, you're willing to put your resources together. And if you're not married for real, you don't want it to be together. I don't know how true that is, because some people want to keep their resources together because I guess it causes less friction. But if you're in immigration filings, if you're filing immigration petitions, you really want to make life easier for yourself, which means get this information to show that your relationship is real. And if you don't have it, you have to explain why. Because, for instance, we have people who don't file their taxes together because maybe their spouse owes money from the government, owes IRS, owes child support, or maybe the accountant told them not to file together. You have to have an explanation why you didn't file together. And I always tell people, even if you're not your spouse doesn't have a social security number, you cannot file single, because you're not single, you're married. So you can file married or married filing single if for instance, for a reason you and your spouse don't live together, because sometimes you have people who don't live together because maybe one of the spouses lives in a different place because of school and all that. In that case, they don't live together. But you really want to make this easier on yourself. So you have to have filed at that time the proof of financial commingling, bank accounts, health insurance, life insurance, proof that you guys are a couple, and hold yourself out to the public to be a couple. So now you're trying to remove the conditions, right? You have to supplement that information, right? So don't submit just the same stuff you submitted before. You have to give them more information as of the date your green card was given to you. So you now have to add more utility bills. You have to show more bank statements from that time, from the time you got your green card to the present time when you're putting in your application. And even when you go for the interview much later, you want to continue to supplement that the information you gave them. So if you have more pictures, if you have a child, you want to have you want to have the birth certificate included. If you bought a house, you want to show that both of you now have a mortgage together. If you've traveled on vacation together, you want to show evidence of that. Typically, they're looking for a slice of your life, right? And honestly, I got to tell you guys this: when you submit sparse documents, right? When you submit things that documents are not enough, you really make it you make it difficult for yourself at the interview, because I believe the officer already has a preconceived idea when they look at your application and there's nothing in there. So they come in thinking that, well, I'm sure this is not a legitimate marriage. So when you're putting in the application, I really encourage you guys to really go robustly as much as you can. If people that know you together, they could write affidavits indicating how they know you to be a couple. Don't use those form affidavits where I know it's a real marriage because they love each other. No, talk about, well, I know it's a real marriage because we all hang out together. We went to watch the Knicks on the other day, and there's a picture attached. We do things together. We go on vacation together. We join them for Thanksgiving. You have to the affidavit from that person has to be personalized. So basically, for that, when you're doing the joint filing with your spouse, the most important thing to do is you need to add more information. And if you don't have any information that would be considered necessary, you want to explain why. All right. Now, we all know that sometimes relationships don't work out, right? The happily ever after doesn't come for some people, right? And there are many reasons for that. Maybe they just are not in love anymore, or maybe there's abuse in the relationship, or maybe the spouse, God forbid, dies, or who knows? There are many reasons why relationships break up. So the important thing to know is that you can still get your permanent green card, even if you're not together with your spouse. And I see a lot of people come to my office. Hi, let me say hello to people on here. Hi, Joe. Hi, Damilola. Hi, Alaji. And hi, Hennessy's. So you can have a relationship doesn't work out. And this is a typical scenario that comes to my office. The relationship is not working out due to abuse. And the immigrant is afraid to get out of the marriage because they think that they have to stay there to get their green card. And I want you guys to know that there is no requirement for you to be in an abusive relationship because you want to get your green card. As a matter of fact, the law is so adamant on making sure that people are safe if they're in marital relationships or any relationships, that they created a waiver exemption for people who already have their green card, and it's a temporary green card, and they're looking to remove their conditions. So one of those waivers is what they call, or exemptions, is a waiver of extreme abuse or extreme cruelty or physical abuse. Now, this is very similar to VAWA, okay? The Violence Against Women's Act. This is similar to that. The only difference is with VAWA, you never got a green card. So I see people who have filed, who have gotten a green card. It's a temporary green card, and they go and file VAWA. You don't have to file VAWA because there's an exemption. There's a waiver that allows you to use that same VAWA, ideology to get your permanent green card. So for that, if you're going to use that waiver, you still have to prove that you were in a bona fide relationship. That's always a given, that the marriage was real, that it was not a sham marriage. And listen to this, USCIS takes another stab at verifying your relationship at this I-751. And unlike VAWA, where you're not questioned about the abuse, right? When you go for an I-751 interview, they will dig into it. And I know it's very traumatic for some people. So it's important to be properly prepared to answer these questions without shutting down, right? Even when I go in as an attorney and I'm listening to some of the questions from my clients who have suffered trauma due to abuse, it's so difficult to listen. But if you're properly prepared, you're able to respond to the questions without, feeling triggered, right? So now for the exemption of the physical abuse or emotional cruelty, you have to show that it was a real marriage, and then you have to show that there was abuse in the relationship, whether it was physical abuse or extreme cruelty. You just give your information. A lot of times you may have to write a declaration, your story, right? And have some information showing them what happened. Now, one thing you do not need is you do not need a police report. You do not have to have a police report to be able to get your green card. You do not have to have hospital reports. Your story just has to be told in a way that is compelling, that the officer can hear your voice. And when you go for the interview, because typically they will call you for an interview for the I-751, you're able to express what went on in that relationship. All right. So, so that's the one waiver, right? The second is divorce. So this is another typical scenario that we get. You know, you see someone who's in a really horrible marriage. Maybe their spouse is threatening to divorce them, and they're so afraid that, and you know, they're pleading with the person to stay with them because they think they're not going to get their green card. Let me tell you, it's better for you, for that spouse, to divorce you, and you want to get that divorce as quickly as possible so that you can use the divorce waiver. The divorce waiver is only effective if you're actually divorced. So if you go for your I-751 interview and the divorce hasn't come through, you're not going to get your conditions removed. So if you're in a relationship that's not working out and your spouse wants to divorce you, listen, let them go ahead. Just make sure that divorce goes through really fast so that you can use that waiver. And when you use that waiver, all you're looking to prove at that point is that it was a real relationship. It was not a sham marriage. It was a bona fide marriage. And you have to, of course, show all this, you know, the things I talked about, you know, update them with other information to show that the marriage continued to be real even after you got your green card. Or if you got divorced shortly after your green card, explain why, what happened. Okay, because everybody's story is different. So your the authenticity of your story can only come through when you are clear about what happened. So don't just send in those documents and not explain why, you know, the marriage didn't work out or what happened. You really have to explain it. Okay. Now, the third waiver is the death of a spouse. And if this happens to you and you have a two-year green card and your spouse dies, which is so unfortunate, you can use that waiver. Again, you have to prove that the relationship when your spouse was alive was a good faith relationship, was a good faith. You entered into the marriage in good faith, and it was a real marriage, and you know, but for the spouse dying. All right. So that good faith requirement is so important, because let me tell you something, guys. Having a sham marriage determination is a death knell. I've told people this before. Google 204C. What that means is that you can never get a green card if there's a determination and you were in a sham marriage, and you can't push back at that. Okay, you really want to be careful about submitting evidence that don't carry any weight, or just submitting your application without putting effort into it, because a determination of a sham marriage is something that could haunt you forever. So the last waiver is extreme hardship. You want to show USCIS that if you were to go back to your country, you would suffer extreme hardship. And this kind of plays in many scenarios. For instance, if your country don't have a TPS, one of those countries given a TPS status, then you could show that you can't go back to your country because there's all manners of craziness going on there, right? Or you know, something changed in your family life, you know, since you came in here, and you can't go back. So you want to be able to show extreme hardship, not your regular hardship. It has to be extreme. Okay. So let me talk about some questions that people ask me regarding the conditional removal. So one of the questions is, let's see, what's the question? I wrote it down. One of the question is, when I filed an I-751, but my 1-year extension is now expiring. What do I do? Okay, so the extension is now 2 years. So I guess the person thought it was 1 year. The extension letter is now 2 years. Let me explain that. When you file your Form I-751, because your green card is going to expire or has expired, you're typically given a card, an extension. It's now 24 months. The reason it's now 24 months is because USCIS is so backed up that it used to be 18 months actually. Is not USCIS is so backed up that they know they can't get through making a determination on what's going on whether or not you can successfully remove your conditions within a short period of time. So they give a 24-month extension letter. So that 24-month extension letter, together with your expired green card, is now proves that you are now your status is now active. Now, remember this, that even if you have an expired green card, only a judge can terminate your green card status. So when your green card is expired, you still have a green card, but you're really not active. So you can't get a job. And the dangers of having an expired green card is USCIS could send you a notice to appear in immigration court and put you in deportation proceedings. So it's really important that you want to make sure that your card doesn't expire. And if you file for a renewal, if you file to remove the conditions of your green card after it's expired, I mean, while that's not the best thing to do, you can still do it. Just go ahead and file it and give an explanation for why you didn't file it before the expiration. Okay. The USCIS is typically very, very generous with accepting excuses. Just make sure it's a good one. So now the other question I have is for people who are trying to, the other question I have is, if you have that extension letter and and the extension letter is expiring or is about to expire and you still don't have any resolution on your case, another question I get is, what do I do? Well, what you need to do is call USCIS office, make an InfoPass appointment, take your green card, expired green card, take your expired or about to expire extension letter, take your passport, and go to your local field office, and they will stamp a 1-year extension. That stamp is I-551, okay? So let's see, what is the other question? Okay, the third question I have is, can I file for naturalization while my I-751 is pending? Absolutely. If by the time if you've had your green card for 3 years, right, and you're still with your spouse, you're still in a marriage with your spouse, and you're still waiting for a determination on your removal of conditions, you can go ahead and file for naturalization, even though your I-751 is still pending. And so what typically happens in that scenario is that USCIS will adjudicate the I-751 removal and the naturalization at the same time. So typically what happens is you go for the naturalization interview, but they first of all remove the conditions. So they go through the I-751 interview first, and then they do the naturalization. So if you have a temporary green card and you've had it for 3 years and you still haven't heard from USCIS with regards to the removal of your conditions, and you're still with your spouse, go ahead and file for naturalization, okay? That's actually a way to get that case moving. So guys, that's all I have for today. Let me see questions that I have, and then I'm going to have to sign off because it's 10 o'clock. So Babatunde Peterson says, when is the best time to file for citizenship? Is it 90 days before the 3 years? Yes, 90 days before the 3 years if it's based on marriage to a U.S. citizen, which the marriage is still in good standing, or 90 days before the 5th anniversary if you got your green card through other ways, such as through your parents, through your employer, through your child, and all that. So that's all I have for today, guys. Instagram didn't work out for me today, but thank you guys for joining me on Facebook and YouTube, and I will see you at the next broadcast. Take care.